the government has moved to really quell FIs tax fears on the issue of minimum alternate tax. The government clarifying that India will close tax cases against FIs with treaty benefits. The government also saying that the final decision and the final version of the finance bill will have more clarity. Will this be enough to quell FI fears? Anu is joining us back on this discussion. Anu, we've heard a lot of commentary yesterday. CBDT chief yesterday saying that the countries that India has a tax treaty with, those FIs will not really be subject to this MAT. But there was also a con call yesterday. You were listening into that. Just run us through all that we've seen on this issue so far.
Sunanda, I've spoken to a few people who are on the conference call where Jayaseelan, Anita Das as well, Shantikanta Das, Anita Kapoor and Shantikanta Das, Revenue Secretary and CBDT Chief, were part of it. The big takeaway, as you already mentioned, is the fact that the tax treaties will override the MAT provisions. So those FIIs which can enjoy tax treaty benefits will not have to go ahead and pay the tax claim that is in, and they should respond to the tax assessing officer immediately with the recognition of that. That's what was said. But more interestingly, and the headline beyond just that, has been the fact that the government has gone one step forward in clarifying on a lot of other tax issues as well. The FIIs raised the concern that they have no clarity when it comes to taxation on capital gains, on bonds as well as other income. The government has clarified to say that before May 7, with the final version of the finance bill, there will be clarity and taxation norms on the same. This comes as a big relief to FIs, because from 1st of April, MAT anyway is not applicable, as the finance bill had stated quite clearly on foreign portfolio investors. The other point to note, a lot of FIs raised the concern that the tax claims have been made onto FIs where the scheme is already ended and the fund has already been liquidated. They were close-ended schemes. So what about those? The government has gone ahead and told these FIs that they can go ahead and make that mention in the reply to tax assessing officers, and that will be taken up, as there is a structural issue in being able to make that tax claim when the fund no longer exists. So all in all, a big relief, but watch out for the final version of the finance bill. It seems to have a lot more details and a lot more relief for FIIs.
I know, just a quick question in terms of what this will mean then for those countries where India does have that DTAA, for example, Mauritius and Singapore. And we understand that a rather significant portion of investments coming from there, almost 30-odd%. The comments that we got yesterday from the CBDT chief, is that enough in your opinion to give the kind of clarity which is required for these FIs, going forward?
Well, Sunanda, as we heard as if yesterday as well, they said we're not looking at India becoming a tax haven, so we don't want India to become like a Mauritius. But the fact that if there is a tax treaty available and it is a registered tax treaty that both the governments recognize, India should be obliged to honor it over and above the tax provisions within the ruling of the AAR, which is a judicial body. So by law, the government is inbounded to react on that ruling of AAR. A quick mention of the fact that a lot of the double taxation treaties, such as Mauritius comes into play, Singapore comes into play. This also will help the government ward off the worry of P notes, because had they gone ahead and done the tax claim, even where the tax treaty was applicable, it would have pushed a lot of FIs back into the P note road, which is something the government would like to avoid in order to reduce the volatility and the ambiguity within fund flows.
All right, let me very quickly welcome in Dinesh Kanabar. He's joining us to really discuss some of those comments that we've picked up. Mr. Kanabar, appreciate very much your time. Let's start by those comments we saw coming in yesterday from the CBDT chief, saying that India is to close tax cases against FIs with treaty benefits. Then India will really give treaty benefits to eligible FIs. In your opinion, is this enough clarity? Is this enough to at least allay sentiment, in your opinion?
So, two parts here. First is it's very welcome that some of the investors who are coming in from countries, and just to clarify, India has tax treaties with 90 odd countries, some of which capital gains tax are exempt under the tax treaty, as you mentioned, like Mauritius or Singapore. And it's indeed welcome that at least in respect of FIIs who have made investments from there, the government does not intend to pursue a levy of book profit tax in respect of the capital gains that they may have made. That said, in principle, I'm actually unable to understand the government's position, because if the government is relying on the Castleton ruling which to my mind is not an appropriate thing to do, but I'll come to that a bit later. Then in the Castleton's case, it was held by the authority of advance ruling that book profit tax ought to apply, and Castleton was a tax resident of Mauritius. So the government's position seems to be a bit ambivalent, although it is very much welcome that at least those FIIs who are coming in from treaty protected countries where there is no capital gains tax, no MAT will be payable.
I will come to this whole contention of, book profits, Mr. Kanabar, but in your opinion, does this allay the concerns, and is this significant? Because we understand about 30% of the investments which are coming in from Singapore and Mauritius, where of course this DTA will apply. So for the moment at least, do you think this is significant? Because some experts speaking with us earlier this morning saying we don't really know how long then this sort of relief will extend to.
So when you say how long, I'm sort of trying to put that question into a perspective. What has happened yesterday, what we heard, apparently are statements which have been made by the Revenue Secretary, by the Minister of State for Finance, and by the CBDT chairperson. One would actually welcome a circular to the effect stating out government's position, because these statements really beyond a point of time have no validity in law, number one. Number two, the question which arises is that if for any reason the ruling of the authority for advance ruling in the case of Castleton is upheld by courts, then in that situation the government will have no option but to go even after those FIIs which are treaty protected, because that's a position in law. And that is where the dichotomy arises. The government in the finance bill has categorically provided that going forward FIIs will not be required to pay book profit tax on capital gains which have been made by them. It cannot be the government's position, to my mind, that the position pre the finance bill and post the finance bill are any different. According to me, the finance bill has clarified the position as it always was, because that was a clarity which was sought by the FIIs. It is not that the finance bill is giving a new relief or a new concession. And but for that relief or that concession, for the past years, book profit tax was actually payable.
You were talking of book profits, and one of the contentions is that the FIs which do invest in India allocate only a small portion really of their total outlay, and therefore this whole question of taxing those book profits don't really arise. What would you have to say to that?
I don't think that's a right position. The right position really is to say, if you have a place of business in India, you have a permanent establishment in India, and you are required to maintain books of accounts, then irrespective of the fact whether the allocation is small or big does not matter at all. The situation is really that FIIs largely do not have a place of business in India, transact with India instead of transacting in India, therefore don't have books of accounts in India, and therefore the question of computing book profits does not arise.
Okay, we've also seen, a trend, at least as an initial trend, where we're seeing some of these FIIs and FPIs really moving away to invest through the P-note route. Could you just give us more clarity? I mean, from a taxation point of view, do you think that, how is this really going to change things going forward?
I think so far as the P-note is concerned, the issue really is that when you have P-notes, you are using somebody else as a front. And if that somebody else who is at the front, who is issuing the P-notes to you, comes from a treaty protected jurisdiction, and the CBDT takes a view that they are not liable to MAT tax, then equally the P-note holder would be eligible to that benefit. If it is that one is coming through again P-notes issued by an investor which is non-treaty protected, the same consequences will apply. But again, I think your question is very, very important. One of your reporters just made this comment that India does not want to be a tax haven. Equally, India does not want to sort of give encouragement to tax havens. And therefore, having this ambivalent position to say that we will apply book profit tax only if you are coming through Singapore and Mauritius may not really be the best way forward for India.
Mr. Kanabar, let's just very quickly talk about the biggest point of concern or the biggest clarity that you'd like to see in the finance bill. You were just talking about that. You're also saying that, the government can't just make these verbal comments. You'd like to see a circular to that effect. In the final then finance bill, what kind of changes, what kind of clarity do you think needs to come in to put this issue to rest once and for all?
The answer to that question has two limbs. In an ideal world, the way I would like to see it is the finance bill, when it is becoming an act, to clarify that the amendment which is made saying that book profit tax will not be payable by FIIs, saying that this clarification is clarificatory in nature. It is a representation of the position as it always stood, and it applies not only to capital gains, but it applies to all other items of income, whether it is interest and everything else. That's number one. Whether that will happen or not, I do not know. What I was alluding to earlier is that today when you hear statements which are made by CBDT chairperson or by Revenue Secretary that they do not intend to issue notices to FIIs who are coming from Mauritius or Singapore because they are treaty protected, that is merely a statement. That statement has no sanctity in law, and therefore it is always a question that will the stand change tomorrow if the people change or whatever else happens.